Mr. Lockhart has a note here on one of these tickets. Did you send a note to the court, Mr. Lockhart?
Yes, I did.
Did not accept your offer to contract and do not agree to these proceedings. All right, so what do you want to do?
I'm not under your jurisdiction. That was the defendant's position from the moment he stepped into this courtroom. But the judge wasn't buying the flesh and blood man argument, and after hearing the same jurisdiction challenge over and over, his patience started running out.
I'm here under threat, duress, and coercion. I'd like to say for the record, my name is Jamil of the family Lockhart.
Let's get the record established. This is the city of Detroit versus Jamel Amir Lockhart. Appearance for the record, please, Counselor.
Rita White, House Counsel, on behalf of Mr. Jamil Lockhart.
All right, Mr. Lockhart.
No one is representing me on my behalf. I don't know that.
All right, go ahead, Mr. Lockhart.
Yeah, so I am Jamil of the family Lockhart, flesh and blood, living man, and attorney in fact for Jamil Lockhart and Legis Trust. I'm here by threat, duress, and coercion. I'm here making a special appearance. And I'm here to demand that the court prove jurisdiction over me as a live flesh and blood man. As I said, I submitted a challenge to jurisdiction. Jurisdiction must be proven and proven on the record. And then also I submitted Freedom of Information Act request for your foreign registration statement and anti-bribery statement, as well as that of prosecutor. There is no contract. Every presentment that was made to me was formally rejected and sent back to the court, which is what you have a copy of, by my notary. I do have a live witness notary who can come in and testify to that fact. Given that there is no commercial contract, no commercial agreement, I fail to see how the court has jurisdiction. Furthermore, there's been no injured party. And no, there's been failure to state a claim through a verified affidavit. So if someone can prove to me how this statutory commercial court has some kind of jurisdiction over me as a live flesh and blood human being, I think we could start there.
Well, let's start here. You have a notice is not what you think notice should be. Notice is what is if it's properly effectuated in the courtroom. And I'll certainly give you whatever hearing that you want if you file the proper motions and material to contest that. I'll give you an opportunity to be heard on that. But furthermore, what I'm looking at is I have a proof of service.
There is no proof of service that was rejected and sent back to the court. You have a copy of that.
You're not even listening. You're not even going to listen. I listened to what you said. Are you going to listen to me?
I am listening to you. I'm just responding to you.
All right. So why don't you listen before you start making statements?
Oh, you had paused. I thought you were finished.
What it isn't.
Well, go ahead.
Are you giving me permission to go ahead now too, right?
I assumed you were done speaking.
All right. Listen, I have an envelope with certified mail. I don't know what I believe the contents have been stapled to the envelope. It's got a proof of service effectuated by Nyla Perrin. I have a signed complaint here, signed by Officer Randy Randolph on 11/19/2019.
Is he here today?
And we can get him in here. Today is only date and time is set for arraignment. So you're just being arraigned, and what the arraignment purposes of your arraignment, and let's go through the whole thing, is you're here for a expired plate ticket. That is a civil infraction that carries a $145 fine. There's an allegation that you did not have a drove while license not valid or improper. That is a misdemeanor offense punishable by 93 days at the maximum by 93 days in jail and or $500 in fine. On the same day and time, it was an allegation that you did not provide proper insurance. That is a misdemeanor, as it's written here, and that is punishable by the maximum possible penalty of 93 days in jail and or $500 in fines. There's also a warrant for your arrest for an allegation of an improper, not valid driver's license. So today is the date and time set for arraignment. You have the option of pleading guilty, not guilty, or standing
The
mute.
defendant kept arguing that the court had no jurisdiction over him because he never consented to the proceedings and had no contract with the state. The judge repeatedly explained that if he wanted to challenge jurisdiction, he needed to do it through the proper court process. But instead of backing off, continued pushing the same argument. Eventually, the judge had enough and warned him that if he kept going, could be held in contempt of court. That warning made it clear the judge's patience was running
Or
out.
standing mute. You stand mute, I'll enter a not guilty plea on your behalf. What would you like to do, sir?
I am here under threat, duress, and coercion to demand
You're
that
not
this
here under threat, duress, or
prove some kind of jurisdiction. And until jurisdiction has been proven, we can go no further. I would also like to ask you, is this proceeding taking place under common law?
This proceeding is taking place in accordance to the court rules and the statutory laws of the state of Michigan.
So I am not a creature of statute. I am not under statutory law. I would demand that this proceeding take place under common law, as I am a live flesh and blood human being, under no authority but that of God.
All right. I'm not going to go back and forth. I'm going to give you another court date. I don't have any All I
need you to do is prove jurisdiction.
You don't tell me what you need me to do, sir. Don't do that. Just let me finish.
With all due respect, the court must prove jurisdiction.
I understand that. We can get this over with quicker rather than later if you let me do my job. What I was trying to say, you're making your claim and stating your case that the court doesn't have jurisdiction over you. In order for me to properly review that and go, it's got to be done according to the court rules. I need a motion, and I will read it. I will read that motion.
I have submitted a motion to dismiss for lack of subject matter jurisdiction.
I don't have it. I don't have it in front of me. And then I'll give you a motion.
I have a timestamped copy of it if you'd like me to show you.
All right, you got to submit it to the court. Look at the.
It was filed by the clerk just 2 days ago.
Okay,
I have a timestamped copy of it.
It hasn't got to the file. I'm going to give you another pretrial date.
I would like to say I do not consent. The court has to prove jurisdiction. I filed that document a few days ago. Anything short of that is an admission that there is no jurisdiction and we have no further business. We have no contract.
Have a great day, sir.
Jamil of the Family Law Card here.
Okay, you're still. Did you have a question, sir?
None other than just stating that I do not consent to these proceedings and I do not accept any contract.
You already put that on the record.
Good.
You came back in.
I would also like to ask why this Mrs. Rita White had claimed to represent me.
All right, let's go back on the record with Mr. Jamil Lockhart. How old are you, sir?
I am 27.
You're 27 years old, and you go ahead and you ask why Miss White is here to represent you. Well, first and foremost,
why did she claim to represent me, and I have no knowledge?
I'll explain it to you. First and foremost, she's the House counsel for this evening. So for this afternoon, she represents anybody who wants her representation as far as helping them to navigate and to defend themselves.
I have never expressed that want to her.
Why do you talk over people?
Well, I assume we were having a conversation. I'm sorry. I'll be quiet.
I am trying to have a conversation, but one's got to talk and one's got to listen.
Okay, go ahead.
You asked why Miss White said she represented you. Miss White said she represented you because she didn't know beforehand the position that you were going to take. So she's just
That's
merely
quite an
doing
assumption.
her job.
That is quite an assumption. Wouldn't you agree?
Well, by the name that you put up on there, Jamil of the family Lockhart,
That is
I
my.
wasn't surprised I wasn't surprised the avenue that you were going to take on that. Just
I'm
by the
glad you
name.
recognize
But I
where I'm
can't-
going.
but she's not going to assume. I don't believe she's going to assume that she's going to treat you any differently than anyone else. And then you said that you didn't want her representation, and she.
Wouldn't you agree that for future reference, it might be better to ascertain that kind of information before she makes that kind of statement for everybody?
No.
You don't think so?
No.
So the assumption is that everyone wants her to speak on their behalf.
Yes, until.
Is that not a rash assumption?
Until they say differently, like you did.
Okay. Well, again, this whole time, there's a motion before the court to dismiss for lack of subject matter jurisdiction.
Well, there's not a motion.
There has been. What has been filed, I have a timestamp copy of it. I can show you that if you need to see it. But your clerk timestamp filed that document.
Let me explain to you. And this is just for your information. You say that you filed it with the court and the clerk down at the window, and I wouldn't disagree with that. But typically you want to, when you do your filings, that's why you want to have a judge's copy, and you want to specifically have that copy hand delivered to the judge's chambers. So we don't rely on the court clerks downstairs at the windows to make sure that these files get put into the proper place. You're not going to make.
Who do you rely on for that?
You're making, and because you don't want to make that assumption that that file is going to get into the correct file. You don't want to make that assumption. Would you agree?
Who do you rely on to make sure that filed documents get into the right place? Get into
the person that's filing it, yourself.
So it is not. You're telling me it's not the duty of the clerk to ensure that documents are filed in the case where the judge can view those documents. On my capacity, that document was sent to the court. It was sent to the court by a notary. So I do have a live witness to attest to that fact. It has also been time-stamped. That was recorded as well. I have checked all my boxes when it comes to notifying the court. I've also given you a demand for your Freedom of Information Act request for your foreign registration statement and your anti-bribery statement. The idea or the fact that you do not have that is an issue, and it would mean that you are committing a crime against me and holding this statutory proceeding and trying to confuse me as a live flesh and blood man, that I am a corporation beholden to the corporation which you represent. And that is my main point here today, is to tell you that I am not under your jurisdiction. I am a live flesh and blood man. You've already stated that this is not a common law proceeding. I am under no law but common law. We have no commercial contract which would enter us into any kind of statutory law.
Okay.
I failed to see the issue. And there's also no verified complaint with a signed affidavit.
Sir, let me stop you. And I'll let you put that on the record. I'll let you put it on the record already. We've already done.
The defendant was convinced that saying, "Why do not consent," was enough to stop the entire proceeding. He challenged the court's jurisdiction, rejected the idea of being represented, and kept insisting that he was only a flesh and blood man. The judge gave him an opportunity to make his argument and explained that the proper motions had to be filed and reviewed. But when the defendant continued repeating the same claims, the judge finally drew the line and warned him about contempt of court. At that point, the courtroom tension was impossible to miss.
Those things. So I'm going to end it.
What you're committing here is a fraud against the people.
Okay.
That's what you're participating in.
Okay. whatever your position
And without
is.
without your foreign registration statement, that's an admission that you are here as a criminal actor.
Okay, sir, I'm gonna end the hearing now. Club.
And I do not consent to
And I'm
any
gonna
further
remove
hearings on this issue or this matter. We have no valid contract. We failed to prove jurisdiction. There is no valid claim.
All right, you've
I do
already
not
said
consent.
that, sir. I've already let you make a record, and I don't want you to mention any more because I'm gonna hold you in contempt of court, okay? So I let you make your record. I set a date.
Do whatever you feel like you need to do. I'm here to tell you that I am not under your jurisdiction.
All right, have a great.
State versus Ashley Clark, 22 CR 216. Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them. But you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well. And that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab them real quick.
Okay. Okay. State has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right. Ms. Clark, any opening statement?
No.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes.
And what was the result of that UA sample from Miss Clark?
It was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes. And I did. I received that. And apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
All right. Do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right. Ms. Clark, You have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski.
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief as set forth by the law.
He walked into court claiming he was a sovereign tribal chief, but when the judge asked for actual evidence, his entire argument started falling apart, and the judge was about to do the work for him.
And would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged.
The defendant kept insisting that the court had to recognize his claimed sovereignty and even argued that evidence proving his position had already been submitted. But the judge made one thing very clear. Mentioning evidence is not the same as actually putting it before the court. If he wanted the judge to consider that case, he had to produce it himself.
That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Present himself on this matter and have our office as standby. I think the court granted that motion, but set this hearing to today because Mr. Evans indicated that he sent a letter to the court that had some requests in it. I don't know if the court received it and if a copy was provided to the city. I have not seen it.
I have not seen it. I looked in the court file earlier today and it was not there. Madam Clerk, do you know if we've received it?
I don't know why you guys haven't received it. Also, can I ask that this hearing is on record and that everything is being documented by a court reporter, please?
We do not have a court reporter. We're creating an oral recording though.
Okay, so will it be on record and
Yes.
Will it be able to be reviewed by federal judges if it gets to that or whatnot? Okay, I can read a copy of the letter. I mailed the letter out. There's no reason it shouldn't have reached you, but the letter had very personal and sensitive information regarding my sovereignty as a chief of a sovereign tribe that's federally and internationally recognized. I don't know why that letter didn't make it to you. I mailed it out last Tuesday, so it should have definitely gotten to you guys by now. I'm having issues with getting to the law library. I've been in the hole. it's like almost impossible for me to legally defend myself with the conditions within the jail. One thing I would like to ask, especially being that you didn't get that letter and I invoke my rights as a sovereign tribe, chief of a sovereign tribe, that if possible, you can give me a PR bond so I can properly get everything to you and make sure it's filed in the courts. I assure you, being that I invoke my rights as a sovereign tribal chief, that I will appear at court dates. I won't play with my rights like that. I have too much to lose. And I have a leg injury. But the main thing is my legal part and the getting the proper defense, and then the mail that I'm mailing out, it's not even getting to you. So I know I'm gonna have an issue defending myself from the inside of this jail. If you could do that for me, I humbly, respectfully ask that you give me a PR bond so I can at least properly defend myself, especially that I invoke my rights as a tribal chief.
I believe we've already had multiple bail hearings. I'm sorry, Madam Clerk, you were saying?
I was just going to say that there was a letter that was faxed in that we received yesterday, and I just forwarded it to all parties.
Okay, thank you. I'm going to take a moment to look at that then. I didn't see it in the file.
In addition to that, I introduced evidence that will exonerate me.
Mr. Evans, I can't read it and listen to you at the same time.
I'm sorry, Your Honor. Also,
Sir, I can't read and listen at the same time. I read slowly.
sorry.
Okay, I've read your letter. You've already had at least one bail hearing, because I remember it. I have not heard any change in circumstances such that you're not entitled to a second bail argument. Bail remains as previously set, $500 per charge. What tribe are you enrolled in?
All of that, I don't want to reveal that information because it's private. That's why I invoked also the Peace and Friendship Treaty between the United States and Morocco, in which I do qualify for that. And also you can contact the Embassy of Morocco.
No, so I'm familiar with that treaty, and it is a trade treaty. It has nothing to do with your right to commit crimes anywhere you feel like.
No, ma'am. It has nothing to do with me committing crimes, but they will vouch that I am royalty, and Morocco has granted me as part of their royalty, and they will vouch for me. I assure you.
You can't be a royalty in Morocco and a Native American. That's not possible.
I assure. If you look at the evidence that I submitted, I assure you I am.
I received no evidence. I received just your letter.
Right.
So I'm not going to. I'm not going to grant your motion to dismiss.
Okay.
What are we doing?
Okay. And I submitted evidence in the letter.
I'm not denying. I'm not granting a motion to dismiss.
I understand, but I submitted evidence in the letter as well.
I've considered your letter, and I'm not granting your motion to dismiss.
I understand.
Okay. What are we doing?
What about the evidence?
What do you want me to do with the evidence? I don't have any actual evidence. I have your statements.
Right. I submitted evidence in the letter. If you read it, you'll see that I submitted a civil case as evidence.
You submitted, you mentioned a civil case. I don't see the civil case. I have no access to this case.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me. And in addition to that, it will prove everything that I'm saying to be true.
I don't have that case, sir, is what I'm telling you. All I have is your letter.
Right. In the letter, I submitted civil case 24012 out of St.
Sir, I don't have that case in front of me. I don't know what's in it. I have no access to it. All I have
You have to retrieve it.
I have no way to do that.
You have to contact the courts.
Sir, that's your job. This is your case. You represent yourself. It's your job to put your case together. It is not the court's job. I ethically cannot do investigation on my own.
No, I'm not asking you to do an investigation.
You are. You're asking me to go retrieve something. That's an investigation.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me.
Then you have to actually get that case and put it before the court.
It's impossible for me to do that inside jail.
You have a standby counsel. Perhaps you can talk to him about it.
Are you going to be able to retrieve that case for me?
1 second. And Your Honor, I can make the records request. I don't know if it's going to have any luck receiving it. I mean, based on the information that I have.
The case has a seal on it, and you're going to have to get permission from the Chief Justice Roberts to get the seal broken.
I don't understand what the U.S. Supreme Court has to do with a Louisiana state case.
Because it holds my rights, as my constitutional rights and privileges as a chief of a federally and internationally recognized tribal chief, in which I represent a sovereign state.
Okay, so what are we doing today?
According to the letter, if you're not going to dismiss it, I asked that in the letter I requested that you file a motion of discovery.
I can't file any motions. I'm not an attorney. I don't represent you. I don't represent the city. That is not my role.
Okay, and you said you're not dismissing due to lack of evidence.
Correct. I have read the police reports and did find probable cause to detain. And some of these cases are in review status. They've already been resolved and found guilty.
Okay, and also in those review cases, I said if the review,
Sir, I'd really like to focus on what we're doing today. I've denied your motion. We need to move on.
Yes, ma'am.
Okay, so what are we doing today? What's the plan going forward?
The plan going forward, I would like a fast and speedy trial by jury. I would like a motion for discovery to be filed. I would like a motion to suppress.
Sir, you represent yourself. You have to file those motions. Nobody, you asked to represent yourself. You got, Judge Rose Akins granted that. So it's up to you to file those motions.
Okay, I just received the paperwork from Mr. Iannetti today on the format to file those motions. So I'll have those motions mailed out tonight.
Okay, perfect. All right, so we're setting this for trial, is what I'm hearing.
By jury.
Okay, so only the pretrial cases are going to be set for trial. I see the pretrial order has all the case numbers on it. Or does it have only the pretrial one? Okay.
I just clicked on it to give him an example of that order as well.
No, I think you've got all the right ones on here.
Okay.
1-5.
And I also asked that that letter be sealed due to the fact it has sensitive information on there regarding me and
you
my
have to
family.
file a motion to seal it, sir. I'm sorry, but this is why it's best not to represent yourself if you don't know criminal procedure. There's a whole process. There's a whole process to having something sealed. I have to make certain findings. I don't have that motion in front of me.
Okay, I requested it in the letter, but I'll file a motion as well.
Okay. But I'd encourage you to read the Bone Club case so that you can understand what the guidelines are for sealing.
I haven't received any of that information, and also I need access to the law library, which is like I don't have any access to the law library.
That's something you'll have to talk to SCORE about. So has any discovery been provided?
I gave him the narratives.
Police reports, that's it.
Will the city, first of all, is there a motion to join and consolidate these cases for trial?
Yes.
Any objection, Mr. Evans?
Yes, I do have an objection.
So then you realize it'll take roughly 4 months to try these cases.
Will I be sitting in jail the entire 4 months, or is it 60 days still?
The problem is we can't try if you're not going to agree to try them simultaneously. I can't guarantee you they'll all be tried within. We only do jury trials 1 week out of the month.
But my question is, will I have to sit in jail 4 months or 60 days?
Potentially 4 months. I can't rule that out. And I'm not trying to pressure you into agreeing. I'm just setting out the facts. You do what you want to do.
I just explained what joinder means, and the benefits and disadvantages of joinders.
So, Mr. Evans, what do you want to do?
I want to do them all separately.
Okay. We'll set them, here's what I'm going to suggest then. I'll put this out to you guys. You tell me what you want to do. Set them all in the June term. And then whichever one goes. But we'll have them all set so that it'll depend on who's available and such. Okay. But they are not joined that unless somebody files a motion to actually hear it. But as of now, nothing is joined. Okay.
Yes, Your Honor.
So the readiness hearing will be on June 12th.
Sit out here.
And jury trial beginning the week of June 24th. And we'll have a hearing on admissibility we'll have a 3-5 hearing. That's a hearing about any statements you may have made, Mr. Evans. And a hearing on admissibility of any 911. I don't know whether there is or not, but just in an abundance of caution. Will you be filing any motions to suppress under Rule 3.6?
I'll be filing motions to suppress and subpoena.
Are there additional witnesses you'll be calling?
Yes, ma'am. I would like to subpoena the airport director or the operations airport so I can have those guys verify that I was there. The reason I was there is legal airport business.
Ms. Tenwaller, is including SeaTac airport operations sufficient to put the city on notice of who the defendant will be calling?
No.
Okay. What would you accept? I don't know how to put this because I don't think Mr. Evans knows who this is right now.
I believe the onus is on the defendant if he wishes to identify and subpoena that individual or individuals.
Okay, so as soon as you figure out who it is, you have to put the city on notice.
Lance Little, the managing director of the airport.
Okay. SeaTac Airport Managing Director Lance Little. I've included that.
Got it.
Will you be offering any affirmative defenses?
Is that a question to me or the?
Yes, it is. It is.
What's your question again? I'm sorry.
Are there any affirmative defenses?
Could you reword that, please?
Perhaps Mr. Ainati can help.
Yes, 1 second.
Yes, ma'am, I do. I will be providing an affirmative defense and the right that I was a law-abiding citizen at the airport.
So I think that's general denial. That's not an affirmative defense.
Well, also that I was a passenger of a business that operates legally in the airport, of a charter bus company that legally operate. I was a customer of a charter bus company that legally operates in the airport.
So still, that's just general denial. That's saying I didn't do it. Not an affirmative defense is saying you did it, but there was that you were allowed to do it.
Right. I was at the airport, and the reason why.
So that is general denial. That is saying there was no crime that was committed. That's what you're saying, right? That you did not commit any crime.
No, I'm saying that I was a customer of the airport. Correct.
It's not an affirmative defense. An affirmative defense would be saying I trespassed, but I had to because I was being chased by someone and I ran into the airport for safety. It was necessity is an affirmative defense.
Okay.
Lawful use of force is a defense.
In that
Just
case,
saying I didn't do it, I was allowed to be there is not an affirmative defense. It's a defense. I'm not saying that it's not a defense. I'm just saying it's not technically an affirmative defense such that you have to put the city on notice.
Okay, according to your definition, I guess it's not an affirmative defense. But once again, could they close the door so I can make sure I'm hearing? Can I re-verify that everything is being recorded and that everything's on file? And I would also like that a court reporter be present for all future hearings and possibly for this one as well, if possible.
We will not have a court reporter. We are not required to. We are not a superior court. We don't have a budget for that. We record everything. Everything is recorded. but we do not have a court reporter. We do not have access to a court reporter, and I'm denying that request.
Yes, ma'am. And then also, could I file a motion to appeal that?
You have to actually file it. You can't, you don't need my permission to file a motion. You can just file it.
I mean, a notice to appeal, I'm sorry. So I would get that information from Mr. Ionetti because I don't have any access to the law library to get these motions or notice of.
Sir, you have to have a basis in law to request that. I can't imagine, we are not courts of record in that sense, like a superior court. We do not have court reporters.
I understand, but I feel my constitutional rights are being violated.
So there isn't a recording of everything. Everything can be recorded and transcribed, but we don't have a real-time court reporter.
Okay, what's the difference? I'm ready, Your Honor.
Okay. And it looked to me like what is current speedy in custody, Ms. Chenweller, do you know?
719.
Thank you. All right, Mr. Evans, bail remains $500 each case. We'll see you back here, each count rather. We'll see you back here on June 12th at 11 o'clock in the morning. Stay in touch with Mr. Ionetti. He can help you.
Ms. Judge, Your Honor, my bail was raised. Is there any explanation for my bail being raised? Some of my cases was $250. It went from $250.
Was it?
Yes, ma'am.
Oh, I'm sorry. Did I mean I just said that I changed it right now? I see that.
It was changed by the previous judge. It was raised to $500. She went just off the notion of what the lawyer said, which was inaccurate. And then the inaccuracy was passed on to you as well. And then you were about to redouble down on it.
All right. Thank you for pointing that out, sir. I'm restoring bail to $500 per case.
You mean $250 for some of the cases? And
well, it's $250 per count on cases that have 2 charges.
All right, let me take a look at the paperwork I got, and I'll let you know which one said $250 bail.
Yes, Your Honor, I believe that the last hearing that it was pro tem judge and she set it at 500 per charge. And I think she misunderstood that when Ms. Chenweller advised her, it was supposed to be 500 per case.
Correct.
Okay, for a case ending in 2319, that was $250 bail.
No, see, there are 2 counts. Look down below it. There are 2 counts. There's 1 count of criminal trespass in the 1st degree and 1 count of making a false statement. Both of them are $250. It's 1 case.
Okay, so you combine the 2 charges and it comes up to 500. I got
Correct. Correct. So it's 500 per case, but I'm restoring it to that. I believe there was a Scribner's error in the last order. And I thank you for correcting me, Mr. Evans, or pointing that out. So it is now, so on the case, and similarly, the case ending in 525, that's the last case. There are 2 charges on that case as well, and it's $250 each charge. Okay. So then.
So was I right or wrong?
You were right. I mean, I put it back the way it was, 500 per case.
Okay, and I'll have trial for all 4 cases on the same day, or?
We can't possibly do all 4 in one day. We're good, but we're not that good.
Gotcha. So, and also the letter that I sent you, it's going to be on file for the public to see all the information I have in there?
Until I receive a motion to seal and we have a hearing on it, yes.
Did you read the backside of it as well? What I said? Okay.
But sir, so this is why I'm encouraging you to look at the Bone Club case, because that sets out the criteria by which a court can seal a document. It's not, I can't just seal it because I feel like it or because you want it sealed. There has to be a justification.
It's a matter of national and homeland security.
You can't just say that. You have to show me why it is.
Because it's an investigation.
So again, you can't just say things. You have to, I need the whole story, not just little bits. And just so you're aware, we are streaming this hearing live on YouTube before you go any further than you want to.
Right. So my whole life is in danger at this moment because of this. I clearly wrote in a letter that I'm connected to an investigation that is a matter of national and homeland security.
But you can't just say that. You have to show me the whole thing. I can't just take your word for it that that's an issue. You're muted. You're muted.
I gave you the evidence to prove what I was saying as well.
But you didn't. You just said, I have this thing. You didn't, I don't have the thing. I need the thing.
I gave you the evidence in civil case 24012 out of St. James.
Okay, we're circling, sir, we're just circling back to things. I do not have that case in front of me. You have to present that case to the court. You can't just say there is a case.
So I have to do it in a motion form, or do I have to, for me to physically get a copy of that, it's impossible for me to do it. My lawyer probably can do it, but it's impossible for me to do it from within inside.
I understand, and we had this discussion at the beginning of the hearing, and you've talked to Mr. Iannotti about that. I can't do any investigation. I am not your attorney. I'm the neutral party. I'm not the city. I'm not you. I will do no investigation. That would be, frankly, I could be sanctioned for doing that. It's up to you to present evidence to the court. It is not the court's job to find evidence.
Okay, in the letter I did present it as evidence.
It's not evidence, it is just claims.
All right, so I actually have to file an actual motion as evidence, and
it's not the motion, you have to file the evidence, the thing itself.
You mean the actual physical copy of the civil case?
Yes, that is exactly what I mean.
I don't have the actual copies of the civil case in front of me due to the fact that I would have to call the courts to get it. And I cannot do that from inside of this jail, and they will not fax that to me from the inside of this jail.
Okay, so we're having the same conversation over again. You can talk to Mr. Iannotti about this, but I can't, there's just a limit to what the court can do. All right, thank you, sir. We'll see you back here on June 12th.
Came into court claiming he had evidence that could completely change his case, but there was one major problem. The judge didn't actually have that evidence. The defendant kept insisting that a separate civil case would prove everything he was saying, and he expected the court to retrieve it for him. But the judge stopped him and made it clear, you have to present that case to the court. And when he explained that he couldn't get the documents from inside jail, the judge gave him another reality check. He had chosen to represent himself, and it was his responsibility to prepare and present his own evidence. What happened next turned into a frustrating back and forth that the judge had already seen coming.